Good evening and welcome everybody. We have a huge number of viewers tonight, indicating the level of interest in tonight's topic. The majority of our viewers are doctors, but some are lawyers and others are representatives of government authorities involved in personal injury management. For those who aren't aware, Australian Medico-Legal College is a not-for-profit educational college with a training syllabus for trainee fellows of the college. And we welcome your inquiries. Our email's on the screen now, as you can see, info@amlcollege.com.au. Tonight's topic is all about conclaves, lawyers and doctors' perspectives, with a brief discussion regarding concurrent evidence in courtrooms. For those who aren't familiar, a conclave is a discussion between two or more experts who've already provided opposing expert reports when a judge instructs the experts to provide a joint report which answers specified questions. In contrast to a pre-trial conclave that I just described, concurrent evidence, colloquially known as hot tubbing, does not result in a report. Instead, the experts are all brought into the courtroom at the same time, and in front of the judge and legal representatives, they discuss amongst themselves, the doctors discuss amongst themselves, the points of agreement and disagreement and their reasons. The concepts of conclaves and of hot tubbing are used to varying degrees in different personal injury jurisdictions throughout Australian states and territories, and in a variety of formats. They may be face-to-face or by a telephone conference. They may include just two doctors or several doctors, with or without a scribe to type the report, and with or without a mediator or facilitator, such as our guest speaker, Karen Stott. Unlike some of the other professions, it's in the core of all doctors, it's in our DNA, to learn off each other throughout our medical careers, discussing better methods of treating our patients. We're taught that our personal egos mustn't interfere with our endeavours to improve our knowledge and advice. Hospital doctors are used to having regular weekly departmental clinical meetings to discuss cases, and even regular morbidity and mortality meetings to discuss poor outcomes and methods of improvement, but in a non-adversarial manner for the betterment of our patients. However, conclaves require new skills and an approach that some IME doctors, that's medico-legal doctors, that some IME doctors find unfamiliar or uncomfortable, because although they're still communicating with colleagues, it's in a potentially adversarial arena. Today, we're fortunate to have as our guest speaker, Karen Stott, who has a long history as a solicitor, but for the past several years has been a full-time mediator, facilitating many expert conclaves. Assisted by our president of the Australian Medico-Legal College, Dr. Drew Dixon, who's undertaken many conclaves, we'll be discussing the reasons for conclaves and how to participate in conclaves in a well-directed, harmonious, respectful, professional manner, fulfilling the needs of the referrers, but without causing angst to ourselves. We're also very fortunate to have as our facilitator tonight, Sue Larson of MEDirect, who's invested a huge amount of time and skills. Sorry, I've just lost my screen. Who's invested a huge amount of time and skills in preparing for tonight. So over to you, Sue. Thank you.
Oh, thank you, Richard. And thank you all for coming tonight. Thank you for also making some of the initial introductions. I'd just like to just quickly introduce Karen Stott, who's Principal of ADR and Mediation Services. She's been a solicitor and now full-time mediator with over 20 years of litigation experience. For the past several years, she's had a mediations practice, facilitating many expert witness conclaves, including matters such as medical negligence and professional negligence. Karen has been a court-appointed mediator to the ACT Magistrates Court since 2017 and was named by Doyle's List as a leading mediator in New South Wales in 2018, 2019 and again in 2020. So Karen, we are very fortunate to have you share your expertise with us this evening. Of course, Dr. Drew Dixon is someone that many of you would know, an orthopaedic surgeon who's both president of the AMLC and of the medico-legal section of the AOA, and of course, Dr. Richard Seckel, occupational medical practitioner and is the co-chair of the AMLC Education Committee. Now, To enable you all to get the most out of the session tonight, there are two pieces of webinar functionality that I'd like to draw your attention to. Firstly, if you move your cursor to the bottom of the screen, you'll see a menu bar that looks a little like the one on screen. So please find the button labelled Q&A and click on this. It will open a question box that looks like this, and you're welcome to submit your questions live as we go through tonight. Thank you to all of those who have already submitted questions leading up to this webinar. We will be incorporating these we have already incorporated these into the discussion for tonight. We may not be able to answer every question live, but we'll certainly do our best to do so. We also have a chat box. So this is the second piece of functionality. If you click on the icon down below, it will open a box that looks like this one. And you can use this if you're having any technical difficulties. We do have some tech team on standby who can help you. I can see there is a hand raised already within our attendees list. If I could ask you please to write a comment, and there's a couple of raised hands, write a comment in the chat box and we'll be sure to respond to you that way. So thank you all for attending tonight. So let's get into this. We have a really large audience of medical experts online tonight, and there are some who've been part of a pre-trial conclave and hot tubbing process before, and others for whom this is entirely new. So for the purpose of us all moving forward together, Karen, could you explain please the process of how it works, starting with a pre-trial conclave and then moving into providing concurrent evidence at court?
Thanks, Sue, and thank you for your introduction and for inviting me to participate in this discussion this evening. The purpose of a pre-trial conclave is to narrow the issues in dispute. Right from the start of litigated proceedings, each party serves expert evidence, and that will just be for one side. Usually, before any matter is allowed to go to trial, the court makes an order that the parties must submit their experts to participate in a pre-trial conclave. That's where they sit down in a meeting, either by themselves or with a facilitator, and they're asked to address a number of questions and perhaps make a number of assumptions to come up with a joint expert report. So I might just share my screen just to say what the purposes of a joint expert conference from a legal point of view. Essentially, they are to assist the court to narrow the issues in dispute. An expert has a duty first and foremost to the court to be impartial and not to give an opinion just in accordance with the relevant party who's briefed the expert. So really, the joint conference enables the experts to have a conversation and agree where possible. That's actually the purpose of the conclave, to see what they can agree on, where they can't agree, to explain their answers. That usually leads to settlement negotiations, and if the matter settles before it goes to hearing, then that satisfies the purpose of it. And then, of course, if the matter doesn't settle and it goes to hearing, the joint expert report can be tendered into evidence, and the experts are usually then invited to give evidence concurrently, which is called the hot tubbing, which we'll come to later. I'll just add one further thing, hot off the press today. A recent New South Wales Supreme Court judgment of Her Honour Justice Lonergan was commenting on expert conclaves, and she mentioned the value that they have to the court. So I'll just read a short amount of what she said. It's long been recognised that there is value in the experts discussing those medical issues between themselves without interference of closed, uninformed, leading or confined questions from counsel that can, on occasion, obfuscate and obscure the issues rather than elucidate them. The real issues sometimes emerge late in preparation of proceedings. Another advantage of the conclave process is those late emerging issues can be distilled clearly and neutral questions posed and answered by the experts. It's of immeasurable value to the court and to the parties for that matter to have the experts address these critical questions in a neutral environment with open, relevantly directed questions that allow the real issues to be the subject of discussion and a joint report prepared before the trial commences. It can aid settlement discussions, it saves time, it enhances the quality and the relevance of the expert evidence focus. So that really is, in a nutshell, what's hoping to be achieved by these conclaves, where the lawyers aren't allowed to be present. That's the main rule of it.
Fantastic, and it's great evidence that is so, relevant, hot off the press today, and so succinct in sharing exactly what the purpose of these conclaves is all about. Drew, I wanted to ask you your comments as well, because you've experienced many a conclave over the time. You've been a participant in it. This section now, actually, just for all of our webinar attendees, we're going to focus now on pre-trial conclaves, and I'd love you to start to submit any questions that you might have regarding this, and then a little later we will move on to hot tubbing. So Drew, you've had a little chance to have a think on some of the recent words that Karen has shared with us from today's press release, and from your own experience, Drew, could you share with us, what do you see as the purpose from a medical expert's perspective? Why are they so important?
Well, I just reinforce what Karen has said, as the principle of amicus curiae, which means a friend of the court. And the expert evidence is not an advocate for any particular party, and their duty is to provide evidence for the court and not for the person retaining the expert. The pre-trial conclave can assist, provide consensus in a collegiate, relaxed teleconference. It will address the issues raised by the questions both in areas of agreement and disagreement and the reasons why. And as Karen has said, it's best done without having another person there, such as a lawyer, although a scribe is useful.
Thank you, Drew. Karen, did you have any further comments to add to that from a legal perspective?
No, I think we'll talk about the role of a facilitator in a moment, but that pretty much sums it up, I think. Thanks, Sue.
Fantastic. Well, let's look at that now, because Karen, many of our audience would never have been exposed to a facilitator during their conclaves before. So firstly, could you clarify for us what kind of cases are facilitators generally used? In what kind of cases?
In my experience, it's common law matters, medical negligence, professional negligence. They're commonly where I facilitate. The Supreme Court matters where the value of the claim is worth a lot, and that they're very complex. Sometimes you get many sets of expert opinions on liability and causation and breach. So complex proceedings that might take weeks in a hearing, they're the sorts that will go to conclave and need a facilitator to bring the report to completion pretty quickly, and to help the experts. I've essentially put on the screen here what the role of a facilitator is in a neutral and non-biased way, to facilitate an environment where the experts produce a timely and cost-effective report that assists the court. It needs to apply with the court practice note, and in every state in Australia, they will have particular rules that need to be applied with. So the facilitator helps the experts to comply with their duty to do that, and to produce that joint report. Really, it's a facilitator is really important to support the experts. A lot of the experts sometimes might not be cognizant of their duty to the court. For example, when I facilitate, I usually send an email to the experts beforehand, introducing myself and making myself available to explain the process. And on one occasion, I had an expert contact me and say that he was new to providing medico-legal opinions. And he actually, through the course of our conversation, it became apparent to me that he was under the misapprehension that his role as an expert was to advocate for the party that had briefed him. So it was important for me as a facilitator to save him from that misconception in the conclave environment, for at least, and to point him in the right direction of the expert code. To manage power imbalances, they are real, as I'm sure you can imagine. One horror example, it wasn't my matter, but many years ago, a barrister's chambers in Sydney held a seminar about conclaves, and somebody from the audience told the story where there were two experts for the defendant briefed in an expert conclave. There was one expert for the plaintiff briefed, and there was no facilitator. The joint report showed that the plaintiff's expert capitulated and ended up agreeing with the defendant's opinions. Then, so the defendants served an offer of compromise saying verdict for the defendant, trying to settle the matter. Not long after that, they received an affidavit and an application to take the matter back to court because the plaintiff's expert alleged that they were bullied in that expert conclave. So what happened is that the court made an order that the parties all had to go back to conclave. And in the second conclave, the plaintiff's expert did not agree with the defendant's experts. So you had two separate joint reports that said completely different things. Now the matter couldn't be settled. It went to hearing, and apparently it was very expensive. And the person in the audience said that, and that was the day, it was her case, that I appreciated that a facilitator is worth every cent, because really they're guiding the process. They're making sure the experts all get a fair hearing, managing those power imbalances, and support the experts in bringing the actual report to completion to make sure all of the questions are answered, and particularly when it's a legal matter that it might have complex nuances of liability, for example, breach of duty, to explain those questions to the experts in a way that translates legally, if you like.
For sure. And I'm looking at some of the questions that are coming in, and thank you for submitting them. We'll touch on quite a number of them, but I know already that there is a question there around bullying. So obviously it's something that is a challenge within the context of a conclave, and when you're in the presence of somebody that's a little more or a lot more domineering, it's very difficult for your opinion to be held, to be heard, and we'll talk a lot more about that. But obviously the role of a facilitator is very can really help in that instance, as well as clarifying legal meanings of words and context. So thank you for that, Karen. I wanted to touch base and drill down a little further on the duties and responsibilities of medical experts in a conclave. And Richard, I know that you have also had a fair bit of experience in a conclave. I was wondering whether you could elaborate on that, duties and responsibilities of a medical expert.
Sure. Karen touched on, in New South Wales, it's called the Code of Conduct. I'm not sure if that's the same name in other states, but I am aware that in most Australian states and territories, there is some similar legislation regarding the duties of expert witnesses. Of course, even if this legislation didn't exist, our professional obligations and our integrity would require us to follow those principles of fairness and honesty, avoiding bias, and providing all relevant comprehensive information rather than just part of the story to meet one side's needs. Mm-hmm. So it's essential for us, before we enter a conclave, to pre-read, before the conclave, to pre-read all the reports written by the other conclave doctor or doctors to identify if there's actually any factual information in my report that had not been available to the other doctor, or conversely, if there's factual information in the other doctor's report that hadn't been available to me. Excuse me. Most legislation deals differently with opinions based on facts compared to opinions based on assumptions. As doctors, we obviously know about that, but the issue isn't so important. But in medico-legal work, and more importantly, as I understand from the lawyers, for the lawyers, that's an extremely important distinction between fact and assumption. Specifically when we're in the lawyer's realm, even though it's only doctors, that is in a conclave, it's essential for us to identify points of assumption as distinct from points of fact, as these might be the reason for the differences in opinions that were provided in the two separate reports that were written by the doctors before the conclave. So if one doctor has based her opinion on fact and the other doctor based her opinion on assumption, the doctors should, in the conclave, discuss whether perhaps on the balance of probabilities, the doctor who based her opinions on assumptions might need to alter her opinion. Yeah.
Definitely. So certainly, you know, what we're hearing is that very much the duty is to the court, and if there are different pieces of information or different perspectives that differ to your original opinion, your duty is to reconsider that and to come to it is potentially the outcome that you do change your opinion from when you went in.
Correct. That's correct.
Absolutely. Karen, from a legal perspective, are you able to add to this?
Yeah, from a litigation perspective, I suppose, even before the matter goes to conclave, it's really important for the plaintiff solicitor right from the start to get the foundation correct in terms of, before you even brief the expert, because the onus is on the plaintiff to prove the case, a lot of work goes in to actually gathering the information, all of the relevant records, getting proper instructions from the client about their version of events, if that needs to be added to any contemporaneous documents, getting all of the records, not just a small snapshot of them. Making sure any factual assumptions that you need to ask your expert to make are rock solid and aren't just going to be not accepted very easily. So that to me is absolutely crucial, to get all of your ducks lined up before you brief an expert right from the start. I actually think that in a lot of matters where mediation isn't available before the orders are made to go to expert witness conclave, it may be because one side thinks that the experts haven't been briefed properly and they're not prepared to enter into settlement negotiations until all of the experts are together and you're sort of comparing apples with apples, and then see what happens once all of the experts have expressed their view and perhaps have learnt from each other facts that they hadn't been given before, all sorts of things like that. So right from the start, it's important that experts be briefed properly and not just given a set of documents and asked to come up with a report without some sort of dialogue with their instructing solicitors beforehand to explore the boundaries of their opinion, so that the solicitor understands that entirely, knows how robust their expert opinion is, so that going into a conclave, knowing that the experts have a duty to try to agree where they can, you can still anticipate, I suppose, how your expert's going to go in conclave when they're talking to other experts and having considered their reports.
And I think that's really key what you're saying, Karen, that, you know, there is an onus on the lawyers to brief the medical expert as comprehensively as possible, so that when the medical experts are in the conclave, they are already equipped with as much information as they possibly can, and they can have that robust conversation without, I guess, any unforeseen surprises that cause them to have to reconsider. You know, ideally the briefing is going to set the medical expert up for success as much as possible. Yeah. We're going to start to look at a couple of questions that were submitted, but before we do that, Karen, I've got another couple of questions for you that have been submitted from some of our webinar attendees tonight, just around the role of a facilitator. I have two, firstly, for you. The first one is, what is the difference between a facilitator? Is it the same as a scribe? But secondly, can an expert request a facilitator?
Well, first of all, a facilitator is different than a scribe. The facilitator can have expertise in the area, usually a lawyer, but it could be another doctor perhaps. But the facilitator, the role is, as I said before, to support the experts in answering the questions, in also talking to them about what they might expect at the hearing, to challenge their opinions, to actually be familiar with the brief. As a facilitator, I will receive the same brief as all of the experts do for the conclave. So I'll know what the experts have expressed before in their various reports, and I'll understand the medico-legal issues. So that helps me assist the experts, because if I notice that an expert is departing from what they've written in their previous report and agreeing with another expert, I'm able to say, you know, that's different from what you said in your report. Are you comfortable with that? It's part of the process, just to make sure that they're expressing a robust opinion in the expert conclave, and to, you know, to make them think about how they're going to feel if it needs to go to hearing. How are they going to be able to substantiate the opinion that they're expressing in the conclave? Because in a room with a couple of other colleagues and a lawyer, it can be easy to forget the big picture and where it all might end up. And trial's not very far away if you're already made to go to a conclave. So that's a very different role to a scribe, who is simply typing a transcript of the discussions in the conclave and writing the report, which the scribe's not really writing the report. It's just recording the conversation. Sometimes as a facilitator, I will do both. I prepare the template report with all of the questions and the assumptions that the experts are asked to make, and setting out where the experts agree, what those issues are, and where the experts don't agree, what each expert opinion actually is. So I'm ready, listening to the conversation, to type in what's relevant. But it just depends on the complexity of the matter. Often a scribe, as well as me as a facilitator, is most cost effective, because you get that report turned around as quickly as possible, which, when there's a court deadline and lots of experts there whose time you need to use very wisely, that can actually be very cost effective to have both a scribe and a facilitator. Sometimes a lot of parties will just have a scribe. It might be a matter of expense. They don't want to pay for a facilitator. A scribe is a stenographer, essentially, with a much lower hourly rate or greater affordability. But that's the essential difference.
Okay, I have another question for you, submitted by one of our audience, and thank you for clarifying that distinction as well. And this is, you mentioned as well about how our medical experts should be briefed, and what a comprehensive briefing looks like for medical experts. This question has come in and it says, is there a set format of questions to be dealt with by the parties so they can proceed in a structured manner in a conclave? You've mentioned that when a facilitator is present, that's often the role that you actually undertake. Do you have any insights, or maybe I might throw to Richard, to you as well, if Karen is unable to comment on this? Are you normally equipped with a set of questions prior if there's no facilitator present?
Oh no, absolutely. The parties, the court rules actually obligate the legal teams on both sides to come up with the questions 2 weeks before the actual conclave, so that the experts have time to consider the brief, consider the questions, and consider their opinion, and not just turn up at the conclave and be given these questions and shoot from the hip. That's a very dangerous situation in my experience. So no, the questions must be settled beforehand, and there's a lot of infighting that can go on about those. And in fact, the judgment of Her Honour Justice Lonergan that I just quoted at the start was an interlocutory dispute about the questions that should be put to the experts. And it was interesting because the parties' lawyers will want to come up with questions that's kind of corralling the experts down a certain way. But the court rules are quite clear that if the experts themselves think that they haven't been asked a question that's relevant, they have the freedom to raise that of their own volition, and they're expected to do that. And Her Honour's judgment also made reference to the fact that questions shouldn't be corralling experts down a certain line of inquiry or to make a certain point. It should be just a generic conversation to enable the experts to elucidate the issues rather than the lawyers corralling it. And lawyers might not like conclaves for that reason. Conclaves are actually a construct of the court to try to facilitate a more affordable legal proceeding. So that's probably a discussion for the lawyers, but yeah, there's a bit of tension there with whether people think conclaves are good or not, or what sort of questions should be permitted.
And I know that we've had some comments submitted that we'll get to in a moment that comment on the involvement of a lawyer as well in a conclave, which we'll move on to in a moment. I have a question that's been submitted during the week. Oh, Richard, yes.
I did want to make a comment on that question, in fact, because by a huge coincidence, one of the conclaves, a recent one that I actually had with Drew Dixon, our other presenter today, was an unusual sort of situation. As Karen said, we are always provided with very specific questions and they have to be given to us well in advance. That last bit, unfortunately, is not always met. That is, it's not uncommon for us to suddenly get a list of the single list of questions the day or 2 or 3 days beforehand, which of course makes it more difficult. Not so much more difficult because, frankly, most of us only address issues like this the day beforehand rather than trying to read it 2 weeks beforehand and then coming back to it 2 weeks. So that's not the issue. But there was a second issue, and that is that one of the questions was raised by one of the parties and the other party didn't agree to it. So the questions that were put to us were, I'd like that question to be answered, even though one of the parties is not happy about it. Mm-hmm. And one of us, it doesn't really matter which one of us, Drew or I, said, no, look, I was advised by the solicitor beforehand not to answer that question, whereas the other doctor said, they got the question to be answered. So we answered jointly all the other questions. One of us answered the question that was in dispute, and the other didn't. And then the questions were sent back to us again, but in fact, before we had to respond to those questions being sent back, and it was going to have to be therefore another part of a conclave to answer that question before it was settled out of court. So I have no idea what happened, but it was that sort of confusion that Karen was talking about. And it was also poorly done because we only got the questions the day beforehand.
And I'll just add to that, Richard, there's one of our attendees on tonight who talked about a conclave that I think she was recently involved in, where she got the questions on the day. And I guess the question is there any recourse? Is there anything that can be done if you are really that poorly, prepared, that you're not given the questions well enough in advance? What are your options?
Sue, I'd like to answer that there.
Yes.
I've actually cancelled conclaves or postponed them in my roles as a facilitator because it's important in managing that power imbalance and that it be fair to experts, that they feel prepared. Not so much in late receipt of questions, but late receipt of briefs. I've sometimes turned up to conclaves and the experts only received the brief by a courier the night before. And one, in fact, received the brief that afternoon and was still reading it by the time that the conclave was due to start. So that's actually the conclave that I postponed because it wasn't fair for all of the experts to proceed when one of them hadn't been briefed on time. And from my point of view as a facilitator, I do try where I can to impress on the instructing solicitors the importance of briefing their experts on time, because what I see in expert conclaves where questions and briefs, but questions where they've been given to the experts on the day of the conclave or even just the day before, what then happens is the experts are less certain sometimes about their opinion. They'll have discussion, good discussion in the conclave, but then after the conclave's finished and I give the draft report to all of the experts, they'll have gone away and they'll have thought more about what the discussion was and what their opinion, what else they'd like to add. Sometimes they'll go and add some more literature that they'll go and find, or add more opinion or change their opinion completely. So I accept that because it's not a closed book exam, a conclave. It's coming up with a report for the court. So I allow any change that the expert wants to make after that conclave has finished. Mm-hmm. And every other expert in the conclave has a right to then respond. So what can happen is the draft report goes round and round in circles many times. It can take weeks to bring to conclusion. And that is largely a result of experts not being briefed 2 weeks beforehand and being given the questions very shortly beforehand. I think a lot of that could be avoided if they were given the opportunity to arrive at the conclave properly prepared.
And I'm seeing a lot of the comments in the Q&A where, the the right way of doing a conclave is not the experience of many of our participants here tonight, and a lot of questions about, well, how should they actually be run? What's a good expectation? What's a good benchmark? And we're going to be talking about that with some of the questions. So let's have a look at one of the questions that's been submitted a little earlier to the webinar. Now, this is one submitted from a defendant lawyer, again for you, Karen, and it reads, when I brief a doctor and they give me their report, I expect them to stand by the opinions they give. I advise my client based on the doctor's findings and the conclusions that they make in their report, and I rely on them not to change their mind in the conclave or make concessions when being examined. Of course, if there is new evidence that may cause a doctor to change their mind, I understand that. But why might a doctor provide an opinion in a report and then make concessions in a conclave during the examination? How do we help a doctor remain solid in their opinion?
That question raises a number of issues for me, Sue. The point that I referred to earlier, albeit to plaintiff lawyers, I really think it's incumbent upon the solicitor to talk with your expert right from the start, not just send them a brief and get a report back, but to explore the boundaries of the expert opinion so you understand it comprehensively. So I wonder whether that situation might still arise if that's actually being done. Also, the expert themselves, you know, that could be a matter for the expert where they do need to be solid in their opinion to a certain extent, but also a purpose of the conclave is to reach agreement with your colleagues where you can. So it's not wrong to actually change your mind if you're able to be swayed by another expert and think of a point that you hadn't really taken into consideration before. It's perhaps a reputational issue for the expert. You need to be careful. You can't just sort of change your opinion with the breeze. You need to actually have given a matter thorough consideration yourself as an expert in being asked to give your opinion and commit that to writing, to a written report, because as the solicitor said, there's a lot riding on it. There's the whole legal proceedings riding on your expert opinion as you've expressed in these reports. So experts are expected to take that seriously. But again, it's not wrong if an expert resiles from their opinion in the conclave process. That's actually a purpose of it.
Mm-hmm. Okay, so Drew, this is a question that is no doubt top of mind for many of the medical experts as they approach a conclave. Now, this question reads, as an IME, I should be wearing my independence and first responsibility to the court as a badge of honour, but I have my opinion and the other guy has another. What advice can you offer to help ensure that I don't get pulled into an adversarial stance and start advocating for one side or the other? And I know we've had a couple of comments as well in the Q&A about, you know, holding your ground and, you know, having pre-thought your report in the first place. How do you actually stand, you know, how do you stand your ground? How do you keep an open mind?
Well, I think you've got to approach it in conclave in an open, collegiate manner and show professional respect for each opinion. The basis of the conclave is that you're trying to receive a satisfactory resolution to the disputes, and you have to agree on some matters, and other matters you will disagree, or you'll agree to disagree, and the reasons why. But the idea is that it's conducted in a respectful way, and there shouldn't be anybody forcing their opinion or sticking so close to their opinion that they can't take a look at the other evidence before them and try and reach a consensus during the conclave. I think a conclave is a good environment in which you can have this experience. It's less formal than a courtroom. I agree that there shouldn't be a lawyer present, and if there's not a scribe present, I prefer to have a scribe, then one of the conclave has got to do the report, send it to the others, and then that becomes the document or the evidence in chief. So I think the conclave is a good way of resolving issues. It won't resolve all issues, but if most of the issues have been answered honestly, then this is often a firm basis in which both parties can reach agreement and avoid the need to go to court.
Thank you for that. Richard, have you got anything that you'd like to add to that?
Yes, I think that questioner said that you should stick to your guns unless there's new information. And I think that the last 5 words of that question, except when there's new information, are very relevant. But new information doesn't have to be just new information provided by the 2 referrers to the doctors who are doing the joint conclave at that stage. It doesn't have to be that sort of new information. For example, new information can also be provided by the other doctor. That is, the other doctor giving a new perspective that we haven't considered. That is a new way of viewing the data that we'd already previously received. So if we stubbornly refuse to even consider the perception of the other conclave doctor, this either assumes that we consider ourselves to be perfect, I'll say that of course in inverted commas, or that we're ignoring the other doctor's perspectives because of our own personal ego, or because we have a misbelief that we have to protect with bias the interests of the party who had originally referred the claimant to us. Of course, all of those are examples of wrong thinking. So new information can actually not just be a new document, but a new way of thinking that we hadn't actually considered ourselves. Also, commonly, one conclave doctor has examined or re-examined that claimant recently, whereas the other doctor hasn't seen the claimant for a long time. I've experienced that actually in a few conclaves. Fortunately for me, I've always been, up till now, the doctor who has much more recently seen the claimant than the other doctor when that was a relevant factor. So in that case, new information didn't come to the other doctor from the referrer, but it came from the other conclave doctor who said, yes, well, since you saw him, this and this and this has happened, which might alter your opinion. So under those circumstances, the doctor who had not seen the claimant for a long time could write something like, assuming that this information is correct, it does cause me to alter my opinion as follows, ... for the following reasons, ... So this is various forms of new information that can cause one of the participants to alter the opinion. That doesn't address the other issues where doctors have different perceptions. They've got all the same information, but they have different perceptions on it. That's a different issue altogether that we'll discuss separately.
Okay,
later.
Thank you for that. Karen, you've talked quite a lot already about what makes a comprehensive briefing and what to expect. Probably just one last little comment. Are there any red flags that doctors, particularly doctors who are new to conclaves, if they experience a briefing that looks like X, it's not okay, and are there any ways of pushback for a doctor? What should they do about that?
Yeah, well, I mean, it's the expert's choice to accept the brief in the first place. And I think beware think about, are you the right expert for this case? Do you have the relevant expertise? Are you still involved in the sorts of matters that you're being asked to comment on? Because there's some pretty nasty case law where experts have been criticised heavily for delving outside their area of expertise or not being as at the coalface as other experts who are more generalists, or experts that don't actually adequately explain their opinion, just give what their opinion is, but without reasoning. So, you know, there are a lot of duties that are expected of experts if they're entering into the forensic area. And also, as I said before, I mean, I can't stress that enough. Just being sent a brief and saying, would doctor please advise, that to me would raise red flags. That to me suggests there needs to be dialogue between the instructing legal team and the expert, rather than just, here's the brief, tell me what case I've got. That's where that lack of communication can have a snowball effect and lead an expert to be more likely to capitulate in a conclave when they see what the real situation is. And so solicitors need to avoid that right from the start.
Okay, thank you, Karen. So we've spoken quite a bit so far on preparation being key to setting a medical expert up for success in a conclave. We've had amongst our audience tonight some really mixed responses as to the values of conclaves based on their own personal experiences. So we're going to move on now and have a look at that. To begin with, we've had a neurosurgeon who described a conclave that he and another neurosurgeon participated in regarding a claimant who claimed that he couldn't move or do up his shoes after a minor motor accident. However, 2 surveillance videos showed him doing ceiling roof and other similar work. The neurosurgeon wrote that the conclave was an excellent opportunity to dissect their various clinical findings and opinions respectfully as colleagues, and he stated the keys for the doctors to respectfully do the dissection of medical matters and not the lawyers. So there was a good scenario and a good experience. Then there's the alternate experience from one of our orthopaedic surgeons who recently participated in a conclave that took 90 minutes via Zoom with 5 medicos involved, and he states there was no new information, none of us changed our opinions, and in my view, nothing was achieved. It seemed like a big waste of time. What is the purpose of all of this? We've had another submission of an occupational therapist online tonight who reported really bad experiences with conclaves, including participants who were refusing to read contemporaneous records, which might have altered their opinion. They instead believed, and we've touched on this already, that their job was to uphold their own report and accept when the plaintiff told what the plaintiff told them, even though it was contradictory to the contemporaneous records. Refusing to provide best practice advice based on evidence-based practice. She's experienced rudeness, including rolling of the eyes, making snide remarks, speaking over the top of others. We've then had other scenarios that have been submitted tonight where there's been 1 defendant medical expert and 2 plaintiff medical experts, a whole range of different experiences, some positive, some not so positive at all. We've also had quite a few questions that have been submitted tonight around, what is the procedure here? What is, because the experience that some have had is not marrying up with how it should run based on what we've already been discussing tonight. So Karen, no doubt you've seen the whole range of these scenarios play out. When conclaves fail, why do they fail, and what does failure mean in this context?
When they fail, a couple of criteria. Often the experts weren't briefed in time. The questions were given late. The expert needs to prepare themselves if they're given the briefing material, actually come to the conclave prepared. And I think Richard was saying before, to have the spirit of congeniality, I suppose. Don't come trying to assert your opinion or be aggressive, because that can really, when you play the man and not the ball, that you see things go pear-shaped very quickly when the experts become annoyed with each other or start exchanging some insults, and that's when they'll dig into their opinions and not have any robust discussion. So that's really, they're the sorts of lack of success factors. And again, I do think a facilitator is really important to guard against those and support the experts and keep everything on track and give each expert fair hearing. You might have one expert who speaks a lot. It makes other experts go into their shell and think, and I've actually heard experts say to me privately, oh, look, it's okay, I'll just fix all of that up in the witness box in court, which is, what the conclave is trying to avoid, you even going to court. So again, to have a facilitator to try to address those imbalances, it guards against the lack of success. And a successful report or conclave process is where the experts might disagree with each other still, but they might find new ground to agree on, and they have a respectful discussion. And yeah, I can go through some examples. It might take a little while. And Drew, I think you wanted to make a point as well.
And Richard, actually. So.
Well, it's just that the one that involved the surgeons have a different psyche there. They are usually right, sometimes wrong, but never in doubt. And you must, when this scenario comes to a conclave between surgeons and whatnot, there has to be a more collegiate atmosphere. There's got to be some respect for the other opinion. And as Richard said, and Karen said, sometimes when the other opinions are expressed, people see there is a difference of opinion and they can move their position to get a consensus. So it is important to have an attitude shift, and when you come in to a conclave, share the information in a collegiate and respectful manner.
Probably the ideal, Drew, isn't it? It's what everybody should be on the webinar learning about, what should be an ideal protocol for conducting a conclave. Richard, I'm going to ask you a little bit more about that as well. You know, are there any differences in the way that conclaves are approached and run that impact on the success? I'm going to add another curly question for you, just to give you a second to think about that too, Richard. You're going to kill me after this, I know that. But that is a feedback from one of our participants who's experienced a scenario where another member of the conclave said, I've given my opinion in my report and that's that. No further discussion. So I'd love you to think about that. How would you answer that? But also, first and foremost, in your experience, when you've been part of a conclave, what are some of the factors that align with success and the ones that don't?
Look, I might address that last one first, only because I'll forget about it otherwise. And I think for me, that's an easy answer. If the other doctor is just going to blockade and just not going to respond to anything, then, well, it would be probably unhelpful to write that exactly, but it might be necessary. If the doctor actually said, I've given my report and that's that, I would then say, Dr. Smith, or probably I'm recording him by his first name, or his first name, do you, is that your response? And if the doctor says yes, then that's the response that must go into the report, and that's easy. And then I give my whole perspective of all the answers to the questions, and the other doctor's given that doctor's one and only response. There is no other response. That the doctor's made it very clear that's the response. If that's the like, I mean, I haven't encountered that circumstance, but obviously the questioner has, and so that would be my answer. That would be the doctor's answer, and my answers would be specific answers to all of the questions. But in response to the other issues that you raised, I have had a few thoughts, and all of these are very basic thoughts that all of us know in theory, but it's actually good to have planned it in advance before, let's say, going into a conclave, which until now is a fairly rare event for most of us. It's become much more common for some of us in New South Wales, and I think in a few of the other states and other jurisdictions as well, it's becoming more common in one form or another. So ensure before the conclave starts that you put yourself into the correct mindset, that you've removed all sense of your own ego from the proposed process, and that you're only seeking the correct responses to fulfill the needs of the independent judge or magistrate who's demanded or requested this conclave to occur. So remove your own ego and remove any sense that you're going into this with any aggression or determination other than your knowledge. So treat the whole thing as a discussion with a friendly colleague, not an adversary, because probably the other doctor has similar apprehensions to you. Most of us can approach conclaves or hot tubbing, as we'll talk about later, with apprehension, because it's not our natural area, like it might be a barrister who goes to court all the time. It's not our natural field of expertise. But before the conclave starts, make sure that you're very familiar with the other doctors' reports, opinions, and evidence of reasons. And at all times in the conclave, talk with respect. I mean, this is obvious, and we've all said this now in one form or another, but it's so important to reiterate it. To talk with respect, be courteous, and most importantly, to listen to the other doctor's opinions. That's really important, not just to be accepting or not accepting of them, but to really listen, so that the other doctor has the sense that he or she is being heard as well. Avoid unnecessary inflammatory words such as right and wrong. You're right, oh, I'm right, you're wrong, etc. Instead, use terms that we should be using anyhow in our reports rather than right and wrong, but use terms such as objective data compared to subjective statements. And as I said before, differentiate between objective fact and assumptions that one or other of us might have made, and be aware of the assumptions. I have to be aware of the assumptions that I have made myself as well, not just the assumptions that the other doctor has made. Use words such as I agree wherever possible, and seek reasons for the differences of opinion, such as that the examinations occurred at different times, like I said before, or that certain pieces of information were not available to one of the conclave doctors. So look for reasons for difference, and at all times, wherever possible, give a sense that you're agreeing where you are agreeing. Choose words that are clear, not ambiguous, but that don't imply that the other doctor is incompetent or has malintent. That's so obvious, but I'm sure that it's too frequently ignored, or the wrong thing happens. Seek, wherever possible, seek face-saving, I'm sorry I have to keep looking down at my screen, but it keeps going off every few minutes. Seek face-saving explanations to assist the other doctor to more comfortably change her opinion if that's appropriate. It's very helpful if you could actually find a way to make it easier for the other doctor to change, or even if you can find face-saving techniques to explain the reasons that you yourself need to change your opinions if it's appropriate. Ensure that when changing an opinion, you provide the basis for the change, which on most occasions will be new information not available at the time of my own assessment previously, but it can sometimes just be a new perspective that hadn't occurred to me at the time of the examination that the other doctor gave. That's okay. That is what the conclave is all about. It's okay. It could happen to all of us that from time to time, the other doctor will actually provide a different way of looking at the situation that we hadn't thought of, but that we think is actually more valid than our own. Of course, I can't imagine it could ever happen to me, but of course it can. Always, as exactly what Karen said, always play the ball, I said not the player, both during the discussion and in the joint report. Address the issues, not the doctor who doesn't appear to be accepting your facts or perspectives. If you agree to disagree, provide clear evidence-based facts for that disagreement wherever possible, rather than assumptions. However, if the other doctor, and this is in response to the last question that the last matter that you raised, Karen, however, if the other doctor remains irritated or aggressive, leave your ego out of it, remain calm, avoid arguing, use silence, a really good technique that many of us in our clinical practices have learned with the odd, rare, unusual person who might come in and act in totally inappropriate ways. Use silence to listen and show respect for what the other doctor is saying, avoiding judgmental comments. Don't tell the doctor to calm down, as this generally only causes more anger. And don't attempt to persuade an angry doctor to agree with your perspective. Just agree to disagree, reporting this in the joint report. So lots of little things. Everybody knows every one of them, but there they are all put together.
So communication skills is key, which is, you know, common in any interpersonal situation, I guess is what we're hearing. I heard a great term today, which was disagree and commit. So meaning it's okay to disagree, but let's just keep things moving forward as well. I've got a question for you, Drew, and it's been submitted in from one of our participants tonight. And Richard, thank you, and Karen as well. Obviously, communication is important, and there are going to be times when, you know, you have to be the bigger man, the bigger woman, and take the higher ground. This is a scenario that's been submitted, Drew, where there were 3 people in the conclave and it got to a 2 against 1 scenario. And the ones that were in agreement said to the other one who was not in agreement, well, it's 2 against 1, so too bad. How would you deal with that, Drew?
I think you have to come at it obliquely, a non-confrontational manner. Just come in very gently, respect the colleagues' opinions is paramount, and be courteous in your appraisal by presenting an alternative. For instance, if someone has suggested surgery or non-surgical intervention, and if, for example, the matter of surgery can be approached gently. And what I mean by that is, don't approach the matter with a forensic ferocity, detailing bullet points as to why one thing should prevail or not, but come in gently and suggest there are alternatives, and that perhaps reconsideration be looked at by the others. It's hard, but if it's non-confrontational and sometimes and they're listening, then your opinion may be necessary for them to reconsider.
And I think that's the same scenario or a very solid response in examples where you potentially are the most qualified medical expert to answer the question, and there's been an alternate position put forward by doctors who are not so qualified to be giving it. How do you actually have that conversation in a way that is not derogatory, that is actually still respectful of your medical colleagues? So thank you for that, Drew. It's interesting.
I think it's important to remember that the legal teams will end up seeing a written report. They won't see the way that the experts are conferring with one another. They won't necessarily, there's a lot lost in translation. They won't pick up on any antagonism between the experts. So if as an expert you find you're in a situation where you're being told it's 2 against 1, remember that the written report's very important, and that if you can at least elucidate your opinion in writing, that's going to be persuasive still, that's going to hold a lot of weight. And also Drew's point, if you think that a colleague is delving outside their expertise, then if something can subtly be committed to writing that tips the lawyers off about that, and that's if there's no facilitator present is my point here, then the lawyers will get the report and be able to pick up on all of that. And as a facilitator, it fascinates me because the conclave process is meant to try to produce a settlement. I often think that if it was like a crime show and there was one-way glass and the lawyers could stand behind the glass and watch the experts in conclave, they'd run away and settle the case immediately, because they would understand the nuances of how the experts are interacting with each other. The most authoritative or persuasive opinions might be more readily observable. That might be lost in translation in a written report. So it's a really fascinating process. But at the end of the day, just remember, your report will go into writing. So if you find yourself in a difficult situation trying to be bullied into expressing a certain view, just so long as your opinion is well explained in writing, then that's the best that you can do, and your instructing legal team will be very grateful for that.
So to that point, Karen, are conclaves ever audio or video recorded so that legal counsel can see? No, they are not. Okay.
Not possible.
Also, another question for you. So I've got the opportunity now to delve into some of the questions that have been submitted. And thank you so much, fantastic audience, for all your questions. It really adds to the richness of the webinar. We really value it and appreciate it. Karen, question is, the comment about what a great idea it is to have a facilitator in a conclave to get a successful outcome, and how valuable it is in navigating the path for a medical expert, and to, leveling different dynamics and explaining legal concepts, etc., or navigating legal concepts. Do all conclaves now have a facilitator?
No, it's really up to the legal teams whether they make provision for that, essentially. And that's why I think if experts feel that they would benefit from one, if you're used to the process and you're being asked to participate in a conclave and there's no facilitator having been arranged, speak up and say, look, I'd like a facilitator, because I'm sure that would be taken into account. But no, I think it's got a lot to do with the expense of the proceedings and the affordability of it. And perhaps I think it's false economy to not have a facilitator to bring that process to completion as quickly as possible, and to get real value out of the written joint report. But so no, the answer is no, not all cases have facilitators at all.
Fantastic. Thank you for that. Another question, are the conversations in a conclave privileged and not actionable by further litigation?
The Supreme Court practice note says that the experts aren't allowed to confer with their legal teams during the conclave process until the expert report is signed and given back to the legal teams. Thereafter, the experts are actually free to talk with their instructing legal teams about what happened at the conclave. So it's an interesting question. Theoretically, I don't know whether they're privileged or not. Matters may come up perhaps in cross-examination at the hearing. I don't actually have any experience because I only facilitate. I'm not a litigator anymore in the hot tubbing and what happens at trial. But I do know that in New South Wales, the Supreme Court practice note does enable the experts to share with their lawyers afterwards what happened. So there's scope, I suppose, for the lawyers to find out any argy-bargy that happened, or anything else in the conclave that the lawyers think's relevant to the to credibility of the experts, for example. They still may be, that still might be sought to make inroads into adversely by your opposing counsel at hearing. So, yeah.
Okay, thank you for that. I've probably got time for 3 more quick questions before we move on to discussing hot tubbing. And thank you all for being so flexible with your response. We've had a couple of our webinar participants tonight say that once they've been part of a conclave, the matter is subsequently, settled, and they never hear back whether their opinion, had any sway whatsoever. They never get any feedback on their participation. Is that normal? And is there any way to understand what level of contribution a medical expert has had in a conclave?
I'd say, unfortunately, it's pretty normal. I don't get feedback either. Sometimes I feel like I'm sending an incoming missile when I hit send on a report, because one side's going to be very unhappy and the other's going to be jumping for joy. But yeah, I mean, I think it's a matter of basic courtesy. It would be nice for solicitors to give feedback to their experts, but by all means, why don't you ask for it? But no, I'd say in my experience, it's not normal to receive feedback, but I'd be interested to hear from Richard and Drew on that.
Yes. No, on odd occasions, I mean, obviously many of the cases we see are of a similar nature, but occasionally there's an interesting situation. I asked the solicitor afterwards, what was the outcome? And invariably, I've never been told an outcome yet, because they all say that the decisions in the jurisdictions that I look at, which is motor accidents and workers' compensation, the decisions are private, or I can't remember what the term is, but anyhow, they can't be divulged. What's the word, sorry?
Settlements. The settlement sum is confidential, but whether it's settled or not, it's not necessary. That can be disclosed.
Yes. No, it's just whether it was settled. No, I'm not asking whether it was settled, but how it was. What was the result? What was the outcome? And I'm always told, no, it's confidential.
Okay, let's move on to another question. And I do apologise to the person who submitted this. Maybe I haven't got the right understanding of it, but it's a question around assumption versus evidence-based versus presumption in terms of the courts. That the understanding is that assumption is a thing that is accepted as true or certain to happen, and without proof. Is this the same in a legal sense as well? Is that what an assumption means, as opposed to a presumption, as opposed to evidence?
In the context of a conclave, if the legal teams come up with factual assumptions that they're asking the experts to assume for the purpose of their opinion, then the experts are obliged to just accept that and not question it, and base their opinion accepting that assumption. If the assumption seems controversial, that's a matter for factual argument in the hearing. I hope that's answering the question. Often legal cases can actually be more concerned with factual disputes rather than an expert opinion. And then that's why conclaves are important, because if there's a factual dispute, then if the experts have given their opinion based on 2 competing scenarios, then whichever scenario wins factually in court, then the court already knows what the experts think about that.
Drew, you've had a lot of experience with conclaves. Do you have any feedback or anything you'd like to share around any of these questions so far that have been submitted?
Well, we've always assumed the conclave is privileged in that because there's no lawyer there, we are talking freely. It's a relaxed atmosphere. We can exchange our viewpoints. We know what we agree on. We know what we agree to disagree on, to produce a document which becomes evidence in chief submitted by the conclave. Now, that document may be sufficient for both parties to work with to resolve the case. And it's been our experience that most conclaves successfully concluded don't go on to the courtroom. because there's sufficient factual information, no controversial assumptions. They can clearly see both parties where the agreements are. They can see where there's disagreement and the reasons given, and they can make a sensible conclusion and adduce the evidence appropriately. So I think that the conclaves that I've been in, I think have achieved a proper result, and we've made every effort to provide the court or the opposing parties with sufficient legal reasoning, shall we say, that they can wrap up the case.
Okay, thank you for that, Drew. I've got one last.
Can I just make one extra comment? Sorry, Sue, and that is going back to the question about assumption. Karen has given a different situation, I think, and I'm not an expert, as she is, on than I was when I was using the word fact versus assumption. In our code of conduct in New South Wales, and there may be similar words in other code of conduct in other states, we are required to advise in our reports what is based on fact and what is based on assumption. And I think in those circumstances, the word assumption is not the assumption that we are often given if the court or a lawyer says, I want you to assume, doctor, that such and such occurred. That's a different sort of assumption to the one I'm talking about. An assumption that we're talking about is that we hear a whole lot of information and we put together a few bits of data which as a group suggest a possible diagnosis, but it's not actual fact. It's just that a group of bits of information cause us to draw a particular conclusion, which is an assumption, rather than saying the person did fall off 2 meters and that's a matter of fact because it was recorded. That's fact. So that's the difference of fact and assumption that I was describing, and the other assumption that Karen described is, I think, a completely different meaning of assumption.
That's right, Richard. Yeah, thanks for clarifying that. And it harks back to right from the start when an expert is providing their original report. It's important to differentiate what the expert knows to be fact and what the expert is assuming and basing their opinion on, so that the reader of the report can understand the difference. Whereas in Conclave, the lawyers will have that it is completely different. They may direct the experts to assume various things for the purpose of their opinion. And that's another interesting role as facilitator, because often the experts don't want to accept certain things as assumptions. Absolutely. And don't understand that they're actually supposed to as part of the process. So, I assist them with that too. But yeah, thanks. It's a very clear distinction, an important distinction that you've made when we talk about assumptions in the context of litigation. Yeah.
Great, thank you. I've got 2 very quick questions. Yes, no responses to these answers, or as close to that as possible. Firstly, can you get sued for defamation from comments you make about an opposing medical expert in a conclave?
No.
No, Drew?
No.
Okay. Next one. Whose responsibility is it to organise a scribe?
The firm of solicitors that is called for the conclave.
Okay, so that could be defendant or plaintiff?
True.
Okay, thank you for that. And thank you again, everyone, for submitting all your questions. We're going to start to move on to hot tubbing or the giving of concurrent evidence. I know there's been a fantastic response to this webinar and so many questions, and I guess if there's any questions that you've got or ones that we haven't answered, please submit them, and we'll, as a group, as a collective, we'll get back to you with some responses, and we commit to doing that. So thank you for that. So what we are going to do now is have a very quick look at conclaves. I'm just going to sorry, I'm just going to put a screen up and drop it back down again, actually. Let's not worry too much about that. We're going to look now at the discussion around hot tubbing. And actually, no, I am going to show you. Sorry, just bear with me 1 minute. I'm going to show you an image because there are some fantastic images of any of you who have not been part of the giving of concurrent evidence before. This is an example. Here we go, sorry.
And I'll just mention, you said that we're going to now talk about conclaves. No, we've just finished conclaves. We're going to talk about concurrent evidence.
concurrent evidence, otherwise known as hot tubbing. Thank you, Richard. Getting my words all mixed up. This is a scenario of how it could look in court when you are giving concurrent evidence, otherwise known as hot tubbing. So we're going to pass on now. Drew has had quite a bit of experience before with hot tubbing. And so, and this is obviously a very different approach to the traditional method of cross-examination where evidence is given independently. So Drew, could you walk us through how does hot tubbing work?
Well, it's a formal gathering of expert witnesses at an enlarged table or a witness box to present for cross-examination in the courtroom. It means you have to be early to be briefed, have typed and bookmarked annotations for quick reference. It means having relevant issues asked sequentially to compare and contrast opinions. It occurs in a more supportive environment in a group of medical colleagues instead of being out there alone as the solitary expert witness out there on the gangplank. Properly directed by the magistrate to confine the matter to the relevant issues, it is an opportunity to address probative evidence sequentially as barristers move through causation, subsequent events, treatment, disputes, as well as apportionment, pre-existing conditions, and further intervening events which may have occurred. It has the advantage that one can modify one's views concurrently, if necessary, as other opinions are expressed.
So by being together with other medical evidence and being cross-examined together or been questioned together, everybody's talking about the same issue at the same time. And there's a real benefit in being able to drill down on specific issues and then move to the next one.
Well, if you go back to the slides of the photos showing the hot tub, you can see the microphone is being passed in sequential fashion. They might ask the one question of each witness, expert witness, or they might ask a group of questions and move from expert witness to expert witness. And then having heard all this, the evidence from the experts, they may then move back and say, Dr. Jones, you've just heard from Dr. Smith, what do you think of that? And sometimes and through that, they start to get a more balanced approach. And it's very easy for those in the courtroom, particularly the magistrate or judge, to see which way the weight of evidence is travelling. If three people in the conclave are all generally in agreement and there's an odd man out, then it makes it easier for the court to, shall we say, appreciate where the conclave's consensus is and move accordingly. I think that a lot of people would prefer to do the more relaxed pre-trial conclave than have their day disrupted by having to attend court, because you've got to disrupt your rooms, you've got to cancel lists, cancel patients. So if you can avoid a hot tub in court, it is preferable. But if you are there, it is a formal process, but you are in it together and there is some support being there as a group.
Well, on that matter, Drew, hopefully, some of the recent changes to our workplace means that in future, maybe some video conference evidence might be used a little bit more in the future, so you're not hanging around all day at court.
Absolutely.
Okay, so we have covered a lot of ground already tonight. We've discussed a whole range of strategies for getting the best outcomes from our pre-trial conclaves, and we've looked at hot tubbing, exactly what that's like, and what some of the advantages can be from hot tubbing. And while no approach is ever perfect, both of these pre-trial conclaves and hot tubbing are recent initiatives of the courts that are designed to improve the process for medical experts while obtaining what we all know as a just, quick and cheap resolution of the real issues in the proceedings. So Karen, some final words and thoughts from you. Do you think that conclaves and concurrent evidence has achieved this? And what parting words do you have for our webinar participants tonight?
So I think the conclave process itself is expensive. So if matters can be settled before you have to go that far, then so much the better. But if it can't be settled and it goes to hearing, then the conclave process is very illuminating to the parties in what the actual issues are, and you do get a lot more settlements that way. And hot tubbing, I think, is an important shift by the court towards putting greater value and respect in experts giving evidence to assist the court, because under cross-examination traditionally, I had an expert once at hearing who ended up in tears at the end of the day under cross-examination and couldn't believe that in trying to assist the parties in the court, she was treated like she was actually a criminal on trial. And that sort of thing is really a thing of the past, and hot tubbing reflects that experts are actually very highly regarded by the courts.
Thank you for that. That's great. Okay, so I'd like to just, I've just got one or two last, let's just see if we have time. So just maybe a quick one for Drew. In a hot tub, I understand it's possible for one witness to call out another witness, pointing down contradictions of inaccuracies. If so, what courtesies need to be observed?
I think the magistrate has to be a team controller. The magistrate has to be very much in charge of the court when it's hot tubbing. He's got to control both legal teams to concentrate on the relevant issues. He can define which way the case is going, and if it's drifting away from the main issues, he can redirect. And if in the conclave one expert attacks another expert, the magistrate will intervene. He must maintain control of the courtroom, and if the barrister's got the wit, he will intervene and say, can we approach this in a different manner? There seems to be a suggestion, a colleague, that might be a difference of opinion. Would you like to comment? In other words, to break it down. I think people that are discourteous in a hot tub, it doesn't affect the person they're criticising, it undermines themselves.
Okay, thank you, Drew, for those comments. I think we've come to time now, so I'd like to thank all of you for being part of tonight, and I'm going to hand over now to Richard to take us out for the evening.
I'm a very different Richard. My desktop just died suddenly. I'm now on my mobile. So there you go, very rapid change. Thank you. Look, in 2020, our world keeps changing in so many ways, of course, but fortunately doctors are used to always learning new information and skills, and successful stress-free participation in conclaves and hot tubbing is just another technique for us to master. So this webinar has been recorded and will be available free on the Australian Medico-Legal College website in the next few days. Just for those of you who are not familiar, I'll just repeat that the Australian Medico-Legal College is a not-for-profit educational college with a training syllabus for trainee fellows of the college, and would welcome your inquiries. We're always happy to consider new trainees and new fellows. So our email hopefully is up on the screen. My little iPhone doesn't show it at the moment. So on behalf of the Australian Medico-Legal College and of all the members of the other medical colleges who also assisted in the very large number of people who are here tonight and who have joined us tonight, I'd like to thank you, Karen, and Karen Stott and Drew Dixon, immensely for your time, effort and perceptive insights into these relatively new processes that many of us are increasingly encountering. I'd also like to thank you, Sue Larson, and your organisation MEDirect for your extraordinary time and energy in facilitating tonight's webinar, using the skills that you and your organisation have created as you've created this practice management system to support doctors in their medico-legal practices. And most importantly, thank you, all of our huge audience for tonight, for your attendance tonight and for the many questions and comments that you've submitted, which have been excellent. In the next few days, we'll respond to those questions that weren't addressed tonight. And we thank you very much again for your interest and your involvement. So good night to everybody.
Thank you. Good night.
Good night.
I know.